Hello, everyone. Welcome to Court with Krissy. If you're a dog lover, this plea might be hard to watch. The end of last year, Smokey, a service dog, was walking with his owner when he was gunned down by a hunter, and unfortunately he passed away. Judge Elmore has some issues with this plea. You'll have to watch to see what happens. And be sure to subscribe because I will be sharing the sentencing. I hope you like it. Court with Krissy is now in session.
We are next taking the case of People of the State of Michigan versus Douglas Allen Barnes. This is file 24-13778-FH. Appearances, please.
Joanna Carey, Chief Assistant Prosecuting Attorney for the People.
Jeff Mankiewicz on behalf of Doug Barnes, who is also present here, Your Honor.
Thank you. You may be seated. Madam Court Reporter, could you please give me an exhibit sticker for the prosecution? Make it exhibit 1. We are here today for a final pretrial conference. And I understand that there is going to be the entrance of a plea pursuant to a pretrial agreement. Ms. Carey.
Thank you, Your Honor. My understanding the defendant is going to plead no contest to count 1, animals killing, torture, and 3rd degree. Count 2. Right now, well, the agreement is for him to plead no contest to count 1. An agreement for a 1-year delay of sentence. If he is successful, then it will be count 1 will be dismissed, and it will be reduced to count 2, the reckless use of a firearm. And the people will be asking for the revocation of hunting rights for 3 years. Oh, and Your Honor, I believe I was reminded there is a request for restitution, also $2,147. Which
Let's
may
hold on.
changed.
Hold on. Take a brief recess in place. Allow you both to talk about whatever it is you need to discuss, and then to allow the court to take a look at a question. Thank you. All right, you ready?
Yes, Your Honor.
All right. We are back on the record for People versus Barnes. All parties present when the court recessed in place a couple minutes ago are still here. Before I turn over to counsel, the question that I have is, under what authority do I have to suspend his hunting rights? It's not a potential sentence considered for the offense. It would then have to be a consideration underneath probationary terms.
It's discretionary report under count 2.
Is it? Well,
And we were going to argue, I did have that conversation with Mr. Wiggins. It's not a surprise. And we had talked about, we are going to argue with the court's discretion to not take that step if the court could take that step based on a number of stuff we'll get into later. But
okay. It's fairly complicated. So let's first make sure we understand what the pretrial agreement is. And then I will ask a couple more questions. Ms. Carey, why don't you tell me again? So I've got the defendant plead no contest at count 1. Count 2 would then be, the agreement is that the defendant will be placed upon a delay under 771.1 parenthetical 2 for up to a year. Then, if he completes the terms of that delay successfully, the defendant could withdraw his plea to count 1 and then substitute for that a plea to count 2.
Correct.
And separate from that, the people are, and the way you said it earlier was requesting That wasn't listed as, the way it was said, it wasn't listed as a term of the agreement, that if people would be requesting the revocation of hunting rights for up to 3 years. Then there was this one, there wasn't a definition of an agreement or request, but there's some amount of restitution, which was $2,147.
That may change, Your Honor, so
Okay.
we would ask that it be held open.
Okay, so hold on. Anything else?
Yes, sir.
Anything else, Mr. Micklitz?
No, that is the plea, Your Honor. Thank you.
All right, thank you. Now, the next thing here I have is a question. Two ways I can deal with these, and I've done them typically in one way. I wonder how efficient it is. It makes sense, and that is, I don't make any statement as to the likelihood of giving somebody a delay. And then I get there, and if I find out enough information, for instance, I don't know anything about Mr. Barnes. If he has no criminal history, the likelihood of getting the benefit is one side of the scale. He does have criminal history and he's got probation violations, then it potentially tips the other way. So let me just ask this question. Ms. Carey, what can you tell me, based upon whatever you have in your file, about the defendant's prior criminal history? I'm asking her first, and I'll turn to Mr. Minkwitz next. Is there anything there?
I don't believe so.
Okay. All right, Mr. Minkwitz.
Your Honor, my client is zero criminal history whatsoever, and on top of that, the prosecution does have about 30 letters from community members, as well as leadership certificates from the Catholic leadership group that my client was part of. He's been an exemplary member of this community.
All right. Now, the next question I have is, are the victims here?
They are.
Okay. Have you, I assume you have, but I'm just keeping it on the record for a reason. Have you talked to them about the agreement?
Mr. Wiggins and Ms. Frick have more than once.
Because I have seen these cases blow up on social media. And when they do, everybody hates the judge, including the victims, even though they are often considered on it. And I don't want.
And
Yeah.
in full disclosure, Your Honor, the victims are not, my understanding is they're not pleased with this.
Yeah, okay. I just want to make sure I talk a little bit about that, because when we get to sentencing, victims have the right to make a statement. And when there is an agreement, let's say there's an agreement to enter a plea and there is no sentence component. Think of that as one thing. If there is a sentencing component, then I, as a judge, have some extra discretion. For instance, if the parties agree to plead to a certain offense and there is no sentence agreement to a deferral, I really don't have much discretion. Plea as the parties presented. I'm kind of, in that instance, I'm kind of like an umpire at Tiger Stadium. However, when it gets to sentencing and we have a delay, all of a sudden my discretion comes into play and I can agree with the deferral or not. Okay. And if I don't, then we kick back to this stage of the proceedings. Okay. One moment. Again, he has no prior record of any kind, other than maybe a driving offense.
No,
like
no
a
prior
traffic.
to it all, Your Honor. He's absolutely exemplary
All right.
in all facets.
If the defendant were convicted of, even at trial, of both counts, he would score on a Class F felony grid It goes A through H. He would score even at the highest 0 to 17, most likely, without running the guidelines. But doing this for a long time, I would estimate that he's probably looking at a 0 to 9 at the highest. Means it's an intermediate sanction cell. The legislature provided some changes in the law a couple of years ago that says an intermediate sanction cell, even though an average person would go, Judge, didn't you just say it could be 0 to 9 months? Yes. However, the legislature says 0 to 9 months isn't actually 0 to 9 months. It's an intermediate sanction cell. And when there's an intermediate sanction cell, I am not allowed to give any confinement unless there are reasonable grounds. The state of Michigan doesn't tell me what reasonable grounds are, but reasonable grounds you tend to look at how they've done in the past on like probation, things like that. In other words, you start off with, I'm ordered by the state of Michigan. My hands would be tied. The most I could do would give them a period of probation and some fines and costs. I hope that's been communicated to the victims. So no matter how we go about this, the law, your legislature says, I can't give them any jail. So that's really difficult. And I understand the position both parties are in. Whether he is convicted of count 1 or count 2 now, it's the same thing. Your legislature in 2020, judges, even if it's a misdemeanor, you have to start with the presumption that a defendant only gets probation, fines, and costs. Even though the statute says, for instance, one of these offenses is a misdemeanor punishable after 90 days. The average person would look at that and go, the judge can give up to 90 days. However, and hopefully this has been explained to the folks, I can't even give them 90 days. I have to start with the presumption of just probation, fines, and costs. If you have it, and so this is what happens. People always like to get online and like to come in here and yell at the judge, even though I explain it to everybody. Don't yell at me. Contact your senator or your House of Representatives rep and tell them you don't like what they did 4 years ago in a lame duck session in 2020 in December, a couple days before Christmas. So now the follow-on question here is, how do I deal with this potential for delay? I'm going to start disregarding delays. So the answer is I'm not going to accept the pretrial agreement with the delay because the law says it's within the discretion of the court. I'm going to put it on the parties. So the parties tell me what he's pleading to or going to trial. So I'm not going to accept the delay. So you guys can take a couple minutes, talk about it. Now that I've explained it to the potential people here in all the people here in the courtroom, I'm not going to let the prosecutor put it on the judge. That's whether or not, because when I get to the delay, I'm likely to say no. You all are going to make an agreement or we go to trial. That way, when you make an agreement, it's the discretion's not placed on me. You make an agreement to plead to count 1 or plead to count 2 or plead to some other charge, that's different because then my discretion isn't there. I take the plea, I find that the defendant's guilty or not guilty based upon what he says or what's contained in an exhibit, and then everybody else can talk to the prosecutor, to the victims or whomever. You all think it's worth pleading guilty to count 2, which again, by the way, folks, means he gets the same no jail. I can't give him jail no matter what. I want you all to make that decision. So I'm putting it back on the people. And I've mentioned this in the past, in the last couple of weeks. I'm going to become very, very strict on ever giving delays. I do not like that. Thank you. We're going to take a recess, allow you guys to talk about it and make a decision. Because I don't want anyone telling the victims, it's on the judge whether or not you get the delay. Prosecutors can tell them, I'm cutting this deal, yes or no, and don't put the discretion on me. Thank you. We are adjourned. You guys will just pass the case and come back to it. Thank you. We're next taking up the case up.
Your
People.
Honor, I'm the only one here, and I'm gonna need a minute.
Okay, no problem. No problem.
Your Honor, thank you. Jeff Mankiewicz back on the record with Doug Barnes. We've switched seats just because my client's hard of hearing in one ear. He's heard everything we've said today.
All right.
It just makes it easier for me to talk to him like this.
No problem. All right. Ms. Carey is here back for the prosecution. Again, Mr. Barnes is seated here along next to Mr. Mankiewicz. What are we doing today?
We do have a resolution, Your Honor, that the defendant will plead guilty to count 2. Dismiss count 1. There's an agreement for restitution in the amount of $2,147 and an agreement that the defendant will lose his hunting privileges for 3 years.
How many? All right. Is that correct, Mr. Mankiewicz?
That's correct. Recitation of the plea, Your Honor. Thank you.
Thank you. Mr. Barnes, is that what you understand what you're doing today?
Yes, it is.
All right, please raise your right hand, sir. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth, sir?
Yes, it is.
You may lower your hand. All right, Mr. Barnes, you are currently charged on a piece of paper called a felony information. It is strictly a charging document. It alleges 2 counts. Oh wait, was it a guilty or not? No contest.
It's going to be a guilty to count 2.
All right, yeah. Count 1 is a charge of killing or torturing an animal in the 3rd degree. That is a felony punishable by up to 4 years and/or up to $5,000. Additionally, consecutive sentencing could be imposed for any other conviction. Plus, there could be up to 500 hours of community service. And the court could also order psychiatric evaluation, cost of prosecution, care, housing, veterinary care, reimbursement. And you may be ordered not to own or possess an animal. However, I'm told that count 2 will be dismissed.
Oh, Your Honor.
I'm sorry, count 1. I said it wrong. I had it in my head, but I just said it wrong. Thank you. Count 1 will be dismissed if you enter a plea of guilty to count 2. Count 2 is a charge of reckless use of a firearm, which is a misdemeanor punishable by up to 90 days and/or up to $500. Additionally, the court may suspend hunting privileges for up to 3 years. Again, I'm told that you'll plead guilty to that count. Is that what you understood, sir?
Yes.
By entering a plea of guilty, you'll not have a trial of any kind. Does that make sense?
Yes.
By entering a plea of guilty, you'll be given up certain rights that you would otherwise have at a trial. That includes the right to be tried by a jury, the right to be tried without a jury if you chose, the court and prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question and cross-examine those witnesses presented against you, the right to have the court order any witnesses you may have for your defense to appear at trial, the right to remain silent during the trial, the right to not have it sauce used against you, and the right to testify if you chose to testify. Do you understand those rights?
Yes, I do.
And do you understand that again, by pleading guilty, you'll be waiving those?
Yes, I do.
Additionally, any appeal as to the conviction and sentence pursuant to the pretrial agreement will be by filing an application for leave to appeal and not a claim of appeal by right. Furthermore, by pleading guilty, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at trial. I forgot a term in the pretrial agreement. I'll go back to it in a minute. Also, if your plea is accepted, you will be given up the right to claim that the plea was a result of any promises, threats, or inducements not disclosed to the court on the record, or the plea was not of your own free choice. Are you entering the plea of your own free choice?
Yes, I am.
Other than the terms of the pretrial agreement, have there been any other promises, threats, or inducements to force or compel you to plead guilty that I haven't heard about? Now, Mr. Mankiewicz has probably talked to you about sentencing, trying to give you an idea as to what the sentencing could be. And we talked a little bit earlier on the record about it. The question I have for you is, has he or anyone made any promises to you as to exactly what the sentence from this court would be?
There was no exact promise, sir.
Thank you. Now, there were two other terms of this pretrial agreement that I forgot to go over. One, I've already kind of covered because I told you this, the sentence could suspend your privileges for hunting for up to 3 years. But there's an agreement between the parties that at sentencing, you would lose your hunting privileges. So get rid of the word may, and you would basically be agreeing to waiving those hunting privileges for 3 years. You understand?
Yes, I do.
Also, there was one other term, and that is there's an agreement that you would pay an amount of restitution of $2,147 to the victim in the case.
Yes.
All right. Knowing all that, do you still wish to enter the plea of guilty to count 2?
Yes, I do.
I failed to ask this question of you, but I already knew the answer. But just to make sure we're clear on the record, turning your attention back to November 27th, 2023. Were you on probation or parole anywhere?
No.
Were you on bond pending any other felony charges anywhere?
No.
Thank you. As to count 2, reckless use of a firearm, how do you plead? Before the court can accept your plea, as to count 2, I need to have you tell me what it is that you did that makes you guilty of that offense. Turning your attention to, again, November 27th, 2023, up in Colfax Township here in Wexford County. What happened, sir?
I fired a gun at an animal and killed him.
So this was during hunting season,
Yes, it was.
and you were hunting somewhere in a forested area, as I understand.
Yes, I was.
And were you on a stand, or tell me a little bit about that?
I was against a tree on the border of federal and state land.
Okay, and then you saw an animal move or something drew your attention, is that right?
Yes, it was.
And as I understand, because I know this was earlier going to be a no contest plea, I read some of the exhibit A, exhibit 1, which we did not admit, but you may have thought it was a coyote, but then you turned and fired it, and you ended up shooting at a pet, which was a German Shepherd. Is that correct?
Yes, it is.
And then the German Shepherd passed away as a result of the firearm.
It ran back to the 2 track and died.
All right, thank you. Ms. Carey, do you believe the defendant has provided the factual basis as to count 2?
I do.
Mr. Mankiewicz?
I do, Your Honor.
Ms. Carey, are you aware of any other promises, threats, inducements?
No, sir.
Mr. Mankiewicz?
I'm not, Your Honor.
And Ms. Carey, do you believe the court should comply with Submission Rule 6.302?
Yes, sir.
Mr. Mankiewicz?
I do.
The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds that the information provided under oath on the record by the defendant satisfies the elements for count 2. Therefore, the defendant is found guilty of count 2, and count 1 will be dismissed at the time of sentencing. Now, the next question here is do we set it for sentencing? If either party is going to seek a period of probation, then the answer is yes. I'll have the Department of Corrections prepare a pre-sentence investigation report. However, even if we don't do that, I assume a prosecutor would want to make sure that the defendant pays the restitution. And the payment of restitution between now and the time of sentencing might influence the defense a little bit. So the question is do we proceed to sentencing now, which we can do because it's a misdemeanor, however, and the victims are here, or if we're looking or seeking a period of probation. Let's find out.
One moment.
A period of probation might be given if we need it. But let's be honest, Mr. Barnes doesn't have any prior criminal history. But it might be, sometimes it's done to allow a period for a defendant to pay restitution.
And for the record, he would not have that issue making that payment very quickly.
Right, and so I don't care what we do, I just want to know, what do you all want to do?
Your Honor, the people would like to see a PSI, as we
Sure.
would likely seek a period of probation. Thank you.
All right, thank you. Because the prosecution has told me that they intend to request a period of probation, the court will have the matter set for sentencing. We typically do sentencing on Monday mornings. I can generally predict it's going to be in about 4 or 5 weeks. Between now and then, a pre-sentence investigation report will be prepared by the Michigan Department of Corrections, also known as a probation and parole office. Mr. Barnes, you're going to get a packet of information. You're going to follow the instructions. Nope, I take that back. You're going to leave the courtroom in a couple minutes, go downstairs to their office. They'll give you the packet and they will set an interview time with you. You have the right to have Mr. Mankiewicz present at that time of the interview. Now, that interviews can also be done via Zoom and things like that. This report will include a description of the offense, description of the pretrial agreement, any statements or information you make while preparing this report, as well as a recommendation as to sentence. It is merely a recommendation. It also might include statements from the victim or victims. The victims also have the right to approach the court and make a statement before a sentence is given. You also would have the right to submit, as Mr. Mankiewicz talked about earlier, other things for the court to consider. Now, Mr. Mankiewicz, I know will go over the report with you prior to coming back to court, as we must make sure that that report is complete and accurate before the court faces a sentence on it. Does that make sense, sir?
Yes, it does.
I trust Mr. Mankiewicz will show you where the probation office is. But in case you all get separated, take the elevator straight down, take a sharp right hook, button hook, and then walk straight ahead through the door. They're in that one hallway. Any objection to continuation of bond, Ms. Carey?
No, sir.
Your bond hereby continues. Anything else, Mr. Mankiewicz?
No, thank you, Your Honor.
Thank you all very much. We are adjourned.